to appeal a break?
Yes.
All right. Are you on probation?
No.
Are you on parole?
This case opens like a slow-motion explosion, a domestic dispute that spirals into police resistance and courtroom confusion. Judge Simpson isn't here to play mediator. He's here to dissect the truth. The defendant, a man who once lived quietly in Saline Township, now stands accused of assaulting his wife and obstructing law enforcement. From a pinch during a heated argument to an alleged strike on a trooper's face, every detail counts. The courtroom tone is calm, but underneath, the tension is combustible. Listen closely as the judge probes. Was it an accident or intent? And how far can one man's confusion stretch before it becomes resistance? This hearing doesn't just decide guilt. It exposes how emotion, misunderstanding, and authority collide inside real American courtrooms.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will, and because you believe that you're guilty of these offenses?
Yeah.
May 20th, 2023, at the location of 3480 Johnson Road, Saline Township, Washtenaw County, State of Michigan. What happened between you and Catalina Phillip that makes you think that you're guilty?
We were having arguments and a little bit of fighting, both of us. Not only me. I pinched her.
You did what?
I pinched her.
You pinched her. Okay. So you were arguing, you were fighting, and then ultimately you pinched her? All right. Did she give you permission to do that?
We didn't talk about permission before.
Okay.
Never happened.
Well,
No, so it's basically no, she didn't.
okay, and she didn't give you permission to pinch her at that time, did she?
No, she didn't.
And you did that on purpose?
I guess. I mean, yes. Yes.
What do you mean you guess? I mean, it's really simple. Did you pinch her on accident, or you? I don't.
No.
Counsel, did you want to do the voir dire?
Yes.
Because please.
Okay.
Here the judge's frustration leaks through. The tone sharpens. The defendant's uncertain responses push the courtroom into a standoff between patience and precision. I guess won't cut it when establishing intent. Legally, intent defines everything. Without it, there's no assault. With it, guilt is undeniable. Judge Simpson demands absolute clarity, accident or purpose. The defendant's indecision undercuts his credibility. This is a classic courtroom tension. Truth filtered through confusion. For anyone watching, it's a reminder. Silence and stammering can be as telling as confession. Would you call this nervousness or evasion? The line is razor thin, and the judge knows it.
On the date and time that the judge did indicate, again, you were at the home of the home in Saline that you and your wife reside in, correct?
Correct.
Okay, and you had been involved in an argument with your wife, correct?
Correct.
And throughout the course of this argument, as you indicated, you had pinched her, correct?
Correct.
And during that pinch, you clearly you did not have permission to pinch her.
Correct.
Okay, and so based on that, did you, in terms of you not having permission to pinch her, you indicated that you believe that she gave you permission, correct?
Correct.
Okay, however, it's fair to say that the police came to the home, correct? Okay, and it's true to say that you had also made admissions while you were in the vehicle that you had touched her without her permission, correct?
Correct.
Your Honor, I have nothing. I'm satisfied.
Hold it, but did he say that at the time he thought he had her permission?
At the time of this argument, and at the time that you had contact with her in which you pinched her, did you believe or did you know that you did not have permission to pinch her at that specific time that you had touched her and pinched her? You did not have her permission. Is it correct or not? To pinch her. Okay, Your Honor, I'm satisfied.
Okay, well, and when the police, trooper showed up, correct? The police showed up? What happened with your interaction with the police?
This is the turning point. The case shifts from domestic conflict to resistance against law enforcement. When Judge Simpson asks about the police interaction, the courtroom quietens. The defense's tone falters. The defendant begins threading words like shocked and didn't know what's happening. That's a red flag for judges. It signals possible mental confusion or an attempt to minimize responsibility. Legally, ignorance isn't a defense, but emotional overload can affect sentencing. Notice how the defendant hesitates to admit resistance. That hesitation itself becomes evidence. In real cases, police body cam footage often destroys "I didn't know" defenses. It's brutal but true. Once the cops give commands, your compliance window is seconds long.
Should I describe everything or?
Your Honor, may I have one?
Yes, please.
Thank you. On that date, you had encounters with a police officer, Jones, correct?
Correct.
And also another police officer, a trooper, actually, Nathan Dillon.
Yes.
Okay. And at some point in time, when the police had come to the home due to the fight that you and your wife had been having, did the police at some point in time tell you to come with them?
Yes.
Okay. And did the police also at some point in time attempt to put cuffs under your
Yes.
back? Okay. So during that process of while the police were investigating this issue with you and your wife, did you walk away?
No.
Okay. Did you in any way, shape, or form oppose the police at any point in time during their interaction with you? Did you fail to obey their lawful commands of either stopping, not moving away from their area?
Yes, I think yes.
Okay, you can't think, either you did or you didn't.
Yes.
Okay,
Well-
and so in a way, did you also, and not in a way, but did you oppose any of their lawful commands, such as, again, did they indicate for you to stop? And did they say stop, and you kept moving at some point in time during this interaction with the police?
Yes.
Okay, and you observed them to have a police badge on them, correct?
Correct.
And they were in a blue uniform?
Yes.
Okay, and so you were aware that they were they were Michigan State Troopers at that time?
Yes, of course.
Okay, and they were affiliated, they were law enforcement.
The defendant confirms knowing the officers were state troopers. This ends any "I didn't realize" argument. Awareness is key in resisting arrest cases. Once he admits he knew they were officers, the defense loses a major angle. Still, Judge Simpson doesn't explode. He methodically traps the man with his own words. Viewers might miss it, but this is judicial precision in action. The tone here isn't cruel, it's calculated. This is how the justice system filters emotion from fact. Every admission builds a chain, and by this point, the links are solid. Would you say the defendant sounds guilty or simply lost? That's what the judge is deciding too, through calm questions that tighten like handcuffs.
Your Honor, I'm satisfied.
Well,
Your Honor, the people aren't satisfied.
pardon?
May I voir dire?
Yes.
Mr. Phillip, when the police were trying to arrest you, did you hit one of the officers?
No.
Okay, and are you aware that one of the officers was bleeding from the face? Are you aware that one of the officers was bleeding from the face?
Yes, I was aware, and I even asked him what happened, and he told me he got.
Okay, and so were you thrashing about when they were trying to arrest you? Were you making movements when they were trying to arrest you?
Yes, I guess I.
No, not, did you or did you not? Okay, I don't think we can take this plea, Your
I
Honor.
don't either. I'm ready for an exam.
Okay,
Troopers are still here.
So I admit I didn't know what's happening. I was shocked.
Sir, let me ask you a question.
Yeah.
They have voir dired you. When the officers were the troopers were trying to arrest you, correct? And during the course of that arrest, did you strike one of the troopers in the face?
This moment is heavy. The judge gives the defendant a direct lifeline. Answer truthfully and maybe salvage credibility. But instead of a clean denial, we get hesitation, confusion, and rambling about not wanting to. That's deadly in court. Judges don't weigh your feelings, they weigh your facts. The defendant's words become quicksand. The more he talks, the deeper he sinks. He accidentally admits that due to the struggle, the handcuffs struck a trooper's face. That's not intent, but it's still assault-level contact during resistance. This line exposes the gray zone between self-defense and defiance. Viewers should pause here. Does shock excuse physical resistance? Or does panic cross into crime?
So from my remember, I didn't. From my remember. So I wasn't willing to hit anybody. I didn't want to hit anybody. Not my wife, not the troopers.
Okay, initially, I'm not asking whether or not you wanted to. Did you?
Yes, the handcuffs, their handcuffs hit the trooper Dylan. He even told me that.
Their handcuffs did what?
Due to the struggle, they said due to the struggle, the handcuffs hit.
Okay, so they were trying to put handcuffs on you, right? What, they get one handcuff on you and then you moved away from them?
I had all my hands behind. And I was on the grass, not on the driveway. They put me on the grass.
They put you down.
No, they moved me from the driveway on the grass. They took me from the driveway to the grass.
I can't get enough to take a plea, because he's not saying he did it.
I agree, Your Honor.
Your Honor, me personally, I understand we're going to proceed to exam, but I spoke to my client and I was very direct in terms of the the nature of the incident, and he was able to make a factual basis.
Okay, that's fine. He has to tell me that. I have to be convinced that there's a factual basis. He is hedging on any interaction he had with the troopers. So I can't even get let alone a resisting. I can't get an attempted resisting out of what he's telling.
I would like to, because I would like to clear.
Here's what I'll do. I don't have anything else to do. Take him back. I'll let you go back there and talk to him.
This exchange reveals a rare moment of judicial fatigue. Judge Simpson openly says, "I'm not going to coerce a plea." That's not weakness, it's ethics. The judge is guarding due process even when frustrated. He's telling defense counsel, fix your client's confusion or face trial. It's fascinating courtroom balance, firmness without force. Many viewers think judges bully defendants, but this scene shows restraint. By refusing to accept a half-hearted plea, Simpson ensures the record stays clean. Legally, a coerced plea can be overturned, so the judge is protecting the very man who frustrates him. Think about that paradox. Justice can't exist without patience.
But I'm not going to sit up here and try to coerce a plea, but if he doesn't, I'll say it, we can go ahead with the exam. So you can take him back and then you can go back there, Miss White, and talk to him.
Ms. Weidling, I have to go help with a motion in the other courtroom. Will you please excuse me? On behalf of the people.
Okay. Sir, you had an adequate opportunity to speak with your attorney.
Yes.
All right. You may continue voir dire, Ms. Bond.
Thank you. Okay, so going back to the date of May 20th of 2023, is it fair to say that while you were in the process of being arrested and a trooper with the last name of Jones was attempting to handcuff you, you pulled away at that moment, correct?
Right.
Okay, and due to the struggle that you were having with Trooper Jones's handcuffs struck the left side of his face, causing him to have suffer injuries, correct?
Correct.
Is that a yes or no?
Yes.
Okay.
Your Honor, the people would be satisfied if that is what actually happened, but it actually struck Trooper Dillon in the face.
I'm just referring
Okay,
to the
you're-
investigator's
all right.
report.
But it struck a trooper in the face. Right?
Yes. But the listed victim is Trooper Dillon. He's the one that suffered injury.
Okay.
Well, let me correct myself. Is it fair to say that it was Trooper Dillon,
Dylan.
who you didn't drive in the scout car with to the jail and the hospital? It was the other trooper that was struck in the face, correct?
Yes.
Okay.
All right. Given that testimony, has the court complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas of guilty to counts 3 and 5.
Finally, the plea lands. Judge Simpson accepts it, and the courtroom tension dissolves into paperwork and procedure. But don't miss the emotional residue. The defendant's confusion lingers, his earlier uncertainty still echoing through every yes and I guess. The plea might close the legal case, but it opens moral questions. Should a man this uncertain be allowed to plead guilty? The court's duty is fairness, not comfort. Still, Judge Simpson ensures that every box is checked, every element of intent acknowledged. In law, completion often feels cold, but it's designed that way. The verdict isn't meant to soothe, it's meant to stand.
Pre-sentence investigation, and counts 1, 2, and 4 are dismissed. Pre-sentence investigation and report is ordered at 1484 probation. Sentencing in this matter will be
July 6th at 9 a.m. with Judge Freshour.
July 6, 2023, 9 a.m. before Judge Freshour. Bond in this matter will continue. Thank you.
Is there a way, I have 2 9 a.m. matters in Detroit that morning. Is there a later time that, say that Judge Freshour will, unless I'm just very late?
That morning, I'm gonna have my own issue running my court, so you might want to call over there because I can't tell you. There is no other time we have.
Okay, I'll be there.
Is your time provided?
Okay, we only have one time provided, so what you can do is you can, I'm certain you can contact your chambers and try to see if you can work something out in terms of timing. All right,
We address bond.
sure, go ahead.
Thank you. Okay, so my client, he is 45 years old, and he actually, when he was first arraigned on this matter, he was ordered a personal bond, I believe $50,000 personal bond. From the interim of when he was placed on that bond, he was not 100% understanding of the conditions of what an actual no contact order encompasses. As a result, he did go back to the home where his wife and him live in Saline, Michigan. His wife was not present at that time. However, based on the no contact order, he was violated and his bond actually reverted to
Well,
changed.
hold on a second, that's not really what happened.
I was gonna add more.
Go ahead.
Yes, and there's apparently he had made phone calls to the complainant. And again, I had not been retained on this matter to make sure he was aware of all the conditions of what a no contact order encompasses. I've had at least 3 2-hour meetings with Mr. Phillip in the jail, and he is very aware of what no contact means, in which he cannot have any telephonic, physical, any type of contact with an individual that a court imposes that order against. So, Your Honor, right, what I'm addressing right now is he is a citizen. He was a citizen of Romania. He came to this country all the way back in 2007, and he came here to pursue education plus work. He actually has a medical degree from Romania. From the time that he came to this country and to the present day, until this case has come about, he has had no criminal contact, any type of prior convictions, etc. He works as a carpenter, he works as a florist. He's very skilled. The home that was actually built in Saline, Michigan, amongst his wife and him and his children that live in currently, he built that from the ground up. He also built a home in Livonia that is now set to be, the occupants are set to be his grandparents-in-law. And that is the home that he will go to if this court agrees to allow him for his bond to revert it back to a personal bond. I see the situation as we know what the purpose of bonds are put in place for is to A, make sure the person appears for all their court hearings, B, does not present a danger to the community or to the complainant, and C, abide by all the contact or any other orders that the court imposes. Now that this was Mr. Phillips' violation in which there was no issues in terms of any contact with the complainant, any violence, anything that would really not be in a position that he should be eligible back to go down to his personal bond status. I believe this is a situation where Mr. Phillip is very aware of the conditions and he will abide by them. He's been in jail for over 35 days, and his parents, I have to make it for a record as an officer of the court, his wife, the complainant, has texted me about 10-20 times begging me to dismiss this case. I'm not the prosecutor.
This section hits hard emotionally. The defense paints the defendant as a devoted father, builder, and provider, pleading humanity over law. Yet Judge Simpson's courtroom isn't built on sympathy, it's built on compliance and accountability. Domestic cases often blur morality. The wife wants reconciliation, but the system wants protection. It's not about love, it's about precedent. Defense attorneys use emotional leverage to show rehabilitation potential, but prosecutors see risk. This emotional tug-of-war defines modern justice. Should family wishes outweigh public safety? Would you release someone just because his kids miss him? That's the ethical storm Judge Simpson must navigate.
And wanting Mr. Phillips to come back to see his children, and she mainly see the children, which she has indicated in her text message that the children are very traumatized that they've been away from their father for this amount of time. I handle juvenile matters regularly in Wayne County, and I understand there's issues that can relate to trauma when parents are separated from their children, especially with this length of time. If this man had a prior criminal history, if he was known to be a very violent person, if he was known to be a person that will not appear in court, yes, I believe this would be in a position where you would not be able to budge or change the bond. But he shows no prior history. His profile does not express any indication that he will not comply with all of the orders. I understand what he did in the past, but with my 20+ years of experience, especially working with individuals to make sure they understand conditions that could bring them back into a position that they clearly do not want to be in, I'm requesting you allow him to be released back onto a personal bond, given the fact that I will not say to a court that, oh yes, I believe he's gonna comply, when I can't even get my clients to comply with my own understanding of them understanding what's going on with their case. But he is very aware, and he does not under any circumstances want to be back in this situation. So I am requesting, given the fact that he does need to continue his contracts with the jobs that he has, to continue to install floors and also make sure houses are actually continuing with the jobs that he's resurrecting with houses and buildings. So I'm asking that you allow him, given the fact that he's been in jail 30+ days, that he be allowed to be released back on a personal bond.
Bruce Brown?
Your Honor, I don't believe he was ever on a personal cognizance bond. I think he was on a cash surety bond. That's at the beginning, but the reason why the bond was changed, actually, this court changed the bond. We've talked about this numerous times. I have spoken to the victim myself, and while she has told me personally that she thinks that he needs mental health treatment, she also told me that necessarily this case is not inside his personality, but at the time she was in fear for herself and for her children and had taken her children out of school because of the violations. And not only that, after he was told by the magistrate these conditions, and it's obvious to me that being in this courtroom today and being at PCC handling this case beforehand, if the judge asks him, do you understand that? And he says, yes, it appeared that his understanding. The magistrate went over the no contact order. He chose to break that twice within 48 hours. He just pled to the domestic violence. I don't believe that the changing a bond is appropriate until after PSIR at least, and to see what kind of treatment he needs to get into. I don't believe the conditions have changed. And while I appreciate what Ms. White is saying, I truly don't believe that she can testify, that she can talk to the fact that he wouldn't do this because he had a prior attorney. Prior attorney and the magistrate told him to not contact her. I also listened to the defendant's jail calls, the ones that are in English. There are not many. He refers to his wife in every single one of them. While he does not say, I will speak to her or have anyone speak to her, he does talk about her in every single one, which leads me to believe that he also might try to contact her, have these calls not been recorded. So I would ask that the bond to change, remain the same.
Anything else?
Your Honor, belief is different from actual actions and facts that can be actually addressed and looked at as factual observations. There's no beliefs that I believe this court should look at as, if it's a belief, then I know he's going to do it. If he has a track record of coming to the house, banging at the door, calling her, there is no track record of that. I have cases right now that I'm.
So why, when he went in and took a shower in the premises, did he feel a need to text her that he was in the house?
Because he was not aware of. He's from Romania. All he mainly talks to me is about Romanian law. But now he's understanding that this is U.S. law. We've talked for at least 6 hours.
But that's not what I'm getting at. What I'm getting at is he waited for her to leave the premises, went into the house, and then, at least as this court took it, were sending communications to her, in essence, almost taunting her that he was in the house.
He was not aware of the full conditions of the no contact order. He had a police standby take him to that home to retrieve his items. He wasn't aware that he was in a position that he could not actually stay in that home. Your Honor, I just don't see that these past actions should now follow through the present. Are past actions going to be something that he's just not going to be able to?
I have no way to necessarily judge anybody, but based on how they conducted themselves in the past, because I am not a predictor of the future. Motion for bond reduction denied. Bond will remain the same. You can bring it up with Judge Freshour. Thank you.
Please subscribe to help the channel.
Judge Simpson ends with calm authority. Motion for bond denied. No drama, no emotion, just the law at work. This final scene underlines why courtroom justice feels both human and mechanical. Every plea, every hesitation, every word built toward this. The defendant's remorse couldn't erase the breach of trust. This hearing reminds us, words matter, even whispered ones. Consent, compliance, and accountability, all tested here. The outcome? A delayed redemption, not a denied one. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.